Okay, so I think last week we talked about FERPTA and Colorado withholding. Does that sound right? And then I think we left off there. Maybe. Okay. If nobody, unless anyone has anything different, that's where we'll pick it up. So Section 16 is the section that deals with any prorations and the association assessments, which that section changed a little bit last year. So we'll talk about that when we get there. But Section 16 just says the following items are going to be prorated to the closing date unless there's some other agreement elsewhere in the contract. And so personal or property taxes, not personal taxes, but property taxes, if any, including being within a special taxing district, or you and I call them metro districts, general real estate taxes, all that stuff. How are we going to prorate that? Is it going to be based on taxes for the calendar year immediately preceding closing? Is it going to be based on the most recent mill levy? Is it going to be based on something else, right? There's no truly correct answer here. You guys can pick whatever you want, but like 99.9% of the time, it's going to be based on the most recent mill levy and most recent assessed valuation, which in most cases makes sense. If you check this box, right, you need to know, okay, well, what was the calendar year immediately preceding closing? Was it, were taxes higher? Were they lower? How is that going to affect my client? You could certainly do something else and just say, hey, like it's going to be a flat fee of $2,500. Where this other box might be helpful, probably unrealistic, but might be helpful, is like on a new build. In the new builds, those the taxes are typically based on the value of the dirt, right? And so the value of the dirt, the taxes might be $500 per year. Well, once the property gets fully assessed and everything else, your taxes might jump up to $4,000 a year. And if the builder has given you credit for, $200 out of those $500, right, it's not going to cover your $4,000 tax bill when it comes due. And so feasibly, you could potentially say, hey, we're going to base this on a projected tax amount, but most builders are not going to do that. Particularly the big builders, they, are very well versed in this stuff. They have attorneys drafting their contracts. So probably not going to do anything there, but it is an option. You can pick something else. You could say other and say none, right? In a hot market, maybe the buyer says, hey, you know what? Save some money on taxes. We're not going to prorate anything. We'll take on the full tax bill, even though you owned the property for part of the year, right? Maybe that's a way that you make your offer more competitive in a competitive market. Not something that I've seen very often, but no, it's available to you. Okay. 16.2 deals with rents. And so if you're just selling a typical, owner occupied or vacant home, and the occupant is going to be out at closing, you're not going to deal with this. If you do have a rental that you're selling where the tenants they have a written lease, then what this tells you is that the buyer has to assume that lease. In the state of Colorado, the tenants have rights under their lease. They can't just be kicked out because the property sells. So buyer has to assume that lease. And then you have to determine, do you want the rents to be based on rents that have actually been received, or do you want that to be based on rents that have accrued? And so accrued just means they're payable, they're earned, basically, they just haven't been paid yet. So again, no right or wrong there, just know how that affects your clients. Security deposits need to transfer as well. I'm not going to get too deep into actual calculations on any of this stuff, just because most of you are not going to sell a ton of rentals. Most of your stuff is going to be single family detached stuff. But if you guys have questions on any of that, just let me know, and we will deal with that. So give me just a second here. Looks like we got a bunch of people trying to join. Okay, hopefully they all get in. Oh geez, they just keep popping in here. Give me a second, guys.
We were on scripts, Bruce. We were a little late on scripts, so sorry.
Okay, it's Harry's fault, so you guys can blame Harry. Let's see. Okay, so hopefully that's everybody. Oh, here we go. Okay. All right. Association assessment. So this section did change, like I said, uh, last year or the year before, I can't remember, but there used to be a section in association assessments. And what it's, it wanted us to put the dollar value of the, monthly HOA dues or annual HOA dues or whatever it was. It used to ask us to put the amount in there. The reason that they took that out was, there were people who would purchase a home in, say, December. And in December, the dues may have been, let's talk about a condo, right? The dues may have been $250 a month, but come January 1, right? Maybe the association determined that, hey, we need to start charging $300 per month in order to, build up some reserves. We have some capital improvements that or some capital requirements based on improvements that we're going to have to bulk up a little bit. And so, that was causing issues because you signed a contract where the seller was effectively stating, hey, our HOA dues are $250 per year. And then by the time you close, it's now $300. And, either the tenant couldn't afford that and it killed their loan, right? And so that created issues, or they closed not knowing that it had bumped up to $300 a year, and then they try to sue the seller for misrepresentation of the fact that the HOA dues were going up. And so they've just done away with that, and they've said, hey, buyer, if you're worried about what the homeowner association assessments are, then you need to go read the association documents, particularly that annual report that talks about whatever things might be upcoming for the following year, any of that type of stuff. So buyer, if you're worried about it, then you go investigate. And if you're not going to read those documents, then you're just going to get stuck with whatever it is that you're going to get stuck with. And that's just going to have to be okay. Right. And so there is still, there's a set of check boxes in here that says if there are any special assessments, so that would be assessments other than those, standard monthly assessments. In some cases, a condo association would do a special assessment for roofs, right? If the roofs all needed to be replaced, they may have to levy a special assessment. If curb and gutters, got destroyed by a snowplow, which was a real thing when I sold my first condo that I lived in. I don't remember what the dollar amount was, but $4,500 or whatever got assigned to every unit because a snowplow had come through and just completely wrecked all of the curbs and gutters and everything else in our association. And so we did have a special assessment when we sold our unit. So who's going to pay for that? The buyer or the seller? Again, there's a set of check boxes, which means there's no right or wrong here. In most cases, probably the seller is going to pay off that special assessment. However, you could certainly make the argument that the buyer is going to be the one who's going to benefit from, the new roof or the new curb and gutters and the new paving, the new whatever it is. And so, maybe the buyer is willing to take that on. It's negotiable, right? There's no right or wrong there. Okay. And then the blank down here just says the seller represents that there are no unpaid regular or special assessments against the property, except for those current monthly or quarterly assessments, or however often the association assesses them. And then if there was a special assessment, you would list it in this blank here. Okay. So, if you have a $3,000 special assessment remaining, then that's what would be listed here. Although if the seller is required to pay that off prior to closing anyway, it really doesn't matter that you list it here, right? More important, if the buyer is going to take on those special assessments, it's important for you to, represent what those special assessments that they're taking on are going to be. Not to say, oh yeah, there's a $1,500 special assessment. Oh, forgot to tell you about the $7,000 one behind it, right? So you need to make sure that that's accurate, know what those assessments are. And you may have to probably talk to the association, the management company, in order to, figure out exactly what those are, the balance on those, right? Some associations allow them to be paid off monthly. Some of them are like, hey, we need a lump sum by the end of the year. It totally depends on the association. the management company, right? So you'll have a little bit of digging to do if there is a special assessment to figure that piece out. Okay. Other proration, so water, sewer, that stuff should be prorated. Propane, if you've got a property, typically if you're dealing with propane, you're talking about a rural property that's not part of a, typical, within city limits type property. So you may have propane that you're going to deal with. Interest on a continuing loan, which you're not going to deal much with unless you're assuming some kind of loan, and then anything else. And in most cases, there's just not going to be any other prorations that you're going to put in here. Okay. 16.5 just says that, unless the parties have otherwise agreed somewhere else in the contract, that any of these prorations that we've listed here are going to be final. And so really the biggest one is probably the taxes, right? If the taxes are $3,000 a year right now at closing, and that's what gets prorated, and then lo and behold, the county comes in and they're like, whoa, property values have been going up. We're going to reassess property values and your taxes are going to go from $3,000 a year to $4,500 per year. Well, that's the buyer's issue, right? We had a final settlement at closing. And so the buyer is going to be on the hook for the full amount of the taxes come next year when taxes are due. Everything there is final. So any questions in anything in section 16? Okay. So possession of the property, it's going to be delivered to the buyer on the possession date and possession time. Where this gets a little bit weird is if you have a post-closing occupancy agreement. And if you do have a post-closing occupancy agreement, it is obviously best to negotiate the terms of that post-closing occupancy agreement right up front. What you definitely don't want to do is if you know that there's going to be a post-closing occupancy agreement, you do not want to wait until you get closer to closing to hammer out the terms of the post-closing occupancy agreement. I've seen 2 issues now where attorneys have had to get involved because brokers have, like the buyer's broker, for instance, put something in additional provisions that says, if the seller needs post-closing occupancy, buyer agrees to do a post-closing occupancy agreement, and then the contract just gets accepted that way, with no post-closing occupancy agreement in place. And then they get a little bit closer to closing and the seller's like, okay, yeah, we're going to need about 2 weeks worth of post-closing occupancy. And the buyers are like, well, I've already made plans. I can't change them, or maybe they say, okay, that's fine, but it's going to cost you $200 a day. And we want a $5,000 security deposit. Well, if that was a thing for your seller, then you should have negotiated that up front. It doesn't mean that you can't negotiate it later, but there's no obligation from the buyer side to agree to whatever, terms you think you're going to need for a post-closing occupancy agreement. And so you absolutely should, hammer out all those details right up front so that there's no question, so that there's no friction as you get a little bit closer to closing. And then your client gets pissed at you and files a complaint against you because now they've had to hire an attorney and bring money out of pocket for that. It's not worth it. Do it up front if there's going to be a post-closing occupancy. Okay. And then if that is the case, right, you'll notice that these terms here are capitalized. And the reason they're capitalized is because they're defined in our contract. And they're defined up in our dates and deadlines section, right? We've got the possession date and possession time. And so if you have a post-closing occupancy agreement, you're probably not going to put delivery of deed because your client is not going to occupy the property or take possession of the property upon the delivery of the deed. So what I'll put in here, if I know that there's going to be a post-closing occupancy agreement, I will just say, see post-closing occupancy agreement. Now, do you really need to do that or do you not? Well, probably not, because if you look at the post-closing occupancy agreement, what it says is that the terms of the post-closing occupancy agreement are going to override the terms of the contract where there's a conflict, okay? But by putting delivery of deed in here when there's a post-closing occupancy agreement in place, it creates confusion amongst the parties, right? And it can just open up the opportunity for there to be confusion. And when there's confusion, you're more likely to have attorneys involved, legal expenses, complaints, all that other stuff, right? And so for possession date and time, I'll just typically say see post-closing occupancy agreement if I know that there's going to be a post-closing occupancy agreement. And that goes for the date and the time. The post-closing occupancy agreement does not have a time listed there. And so one of the things that I'll do in the post-closing occupancy agreement is I'll go down and I'll write in, possession to be delivered at 12 o'clock noon or 5 o'clock PM or whatever the time is, so that there's no question as who gets that day, right? The last day is possession being delivered first thing in the morning, last thing in the evening, somewhere in between, right? So just make it clear that, hey, this is the time upon which that possession of the property is going to be transferred if there's that post-closing occupancy in place, okay?
Hey, Jesse, wouldn't the deed be transferred still at closing though?
Yeah, the deed still gets transferred at closing, correct. But I guess what question do you have? Do you have a question in relation to possession?
Okay, never mind. I was getting confused with delivery of deed there, but okay, never mind. I understand.
Yeah, so typically without a post-closing occupancy agreement, right? Typically what I'll put is delivery of deed, or some people put delivery of deed and funding. But delivery of deed, it would be your typical transaction where you don't have a post-closing occupancy in place. But yes, in a post-closing occupancy situation, the deed still transfers, but possession is not going to transfer, right? Okay, let's see here. So this is where we also set forth the per diem charge if the seller fails to deliver possession as specified, right? And so the important part here is it says if seller after closing, so in other words, buyers close on the house and the sellers fail to deliver possession to the buyer, then the seller would be subject to eviction and additionally liable for whatever the per day amount is. Now, the interesting thing right now is although we don't truly have what I would call an eviction moratorium, it is a de facto eviction moratorium. Okay, there are ways to effectively what they've done is they've lengthened the amount of time that a landlord has to give a tenant before they can even initiate the proceedings to really start the process of eviction. But the problem is, even if they go through that now lengthened process due to COVID, right, whether the court agrees to even take on an eviction case right now is highly doubtful. And so even if the landlord has gone through all the hoops, the judge could look at it and go, yeah, I'm not going to evict somebody in the middle of, a COVID pandemic, right? Whatever you want to call it, right? The judge still has the discretion to say, no, I'm not going to evict these people. And that's what we've been seeing largely, is that it's impossible to evict these people. And so, you need to make this sufficiently painful enough if there's going to be some kind of occupancy after closing, or even if you don't have a post-closing occupancy, even if the seller is just supposed to deliver possession of the property to the buyer upon the delivery of the deed, right? What happens if they don't? It's going to be very difficult to evict them. And now your clients have a truck full of stuff that, they're moving from out of state, right? Whatever. So now they've got to rent this truck at a premium. They're now going to have to stay in a hotel because they sold their other home. They've got food that they can't, go cook in a kitchen because they don't have one, whatever, right? And so it's going to cost them more to eat out. Now they've got attorney's bills that they're going to have to pay. So this needs to be sufficiently painful enough that the seller has motivation to get out of the property and deliver possession to the buyer. Okay, there is also a section just like this in the post-closing occupancy agreement. And, in a competitive market like we have right now, buyers are wanting to be, very flexible with this possession thing with sellers in order to hopefully get their offer accepted, right? And so what a lot of buyers are doing is they're saying, yep, I'll let you keep possession of the property for 30 days or 15 or 60 or whatever it is, right? And there's going to be no rent for the term. There's going to be no security deposit. and there's going to be no per diem penalty if the seller fails to get out, right? And that's extremely risky from a buyer's perspective. And so if you're working with a buyer, I don't care if you don't want to do rent for, whatever the term of the post-closing occupancy is. I really don't even care if you want to do the security deposit, but this needs to be painful. Okay. In my opinion, it needs to be painful, because if you put $0 per day in there, you're effectively telling the seller it's not going to cost you anything to stay in the property after closing. Okay. That's probably not what your buyer has in mind. So what's acceptable there? I don't know. There's not a right number, but whatever gets the seller motivated to move out of the property, whatever is enough to cover the buyer's expenses if they have to, keep the truck and rent the hotel room and pay legal fees and whatever else. Okay.
So Jesse, real quick, if I can. So
Yep.
I recently had to do a post-occupancy agreement.
Mhm.
And so there is a section in the post-occupancy for similar, like a per
Yep.
day or rent back or whatever. So are you saying that this dollar amount should differ from what the post-occupancy says? Or, I mean, I know
No,
the post-occupancy overrides, so I guess I'm confused. Like, if there is a post-occupancy, what do we do with that?
yeah. So I'm not saying they should be different. And honestly, in most cases, I would make them the same. This is really not going to apply in most cases if there is a post-closing occupancy in place, because the post-closing occupancy would override. However, not every deal is going to have a post-closing occupancy. And so we have to have this provision in the standard contract as well. And then if we have that post-closing occupancy, that would override this section. And so I'm just saying whichever one applies to your situation, right? If there is no post-closing occupancy, this needs to be painful. If there is a post-closing occupancy, it still needs to be painful. You can pull the number through, right? And just use the same number, whatever that happens to be. So yeah, in most cases, there's not going to be a difference. And if there's a post-closing occupancy, it's not going to matter if they're different anyway, because the post-closing occupancy is going to override and the seller has possession through the post-closing anyway. So this wouldn't kick in. Does that make sense?
Jesse, yeah, I've got a quick question on that too. So in this crazy market that we're seeing, a lot of post-closing occupancies are no charge. So how does that work with all this?
Yeah, good question. And I don't care if it's no charge, and I don't care, like I said, even if it's no security deposit, I still want you to have a post-closing occupancy agreement in place, but particularly for this reason, right? So that if the seller fails to get out, that there is some type of penalty assessed against the seller for not delivering possession as specified. And there's other provisions in there as well, and it's changed a little bit, but so they've taken out the hazard insurance part, the homeowner's insurance part, right? Now the only option is for the renter's insurance or contents insurance, right? But still, that's something that you want to, determine who's, is the seller going to get a renter's insurance policy for their personal belongings? You probably want that to happen, right? So that your policy isn't on the hook for covering all of their personal belongings and everything else, right? And then it also talks about who's going to pay for water and sewer. And it spells out a lot of other things that are associated with a lease that a purchase contract just doesn't deal with. And so again, I don't care whether it's zero rent for the post-closing occupancy term, and really even if it's zero security deposit, I still want you to have a post-closing occupancy agreement in place. It's just the safe thing to do. That's why that form exists. So what a lot of people are doing because they're lazy is they're just coming up here in the dates and deadlines, and they'll put a closing date, of today, April 13th, right? And then they'll put the possession date as April 30th. And then there's no post-closing occupancy agreement in place. And that's a terrible, terrible way to do it. Okay. It can just create massive issues later if the seller fails to leave, or if, they damage something in the property or whatever else, right? So the post-closing occupancy ties up all those loose ends, regardless of the dollar amount that's being charged. Does that make sense?
Yes, thank you.
Okay. Buyer, this last little sentence in here is that the lender really needs to know, is this an owner occupied deal? Is this the buyer's primary residence? If it's not, they need to check this box, because they're going to if they're getting a loan in particular, the lender needs to know that, because they're probably going to get a higher interest rate and everything else. Still have to check the box, even if it's a cash deal, because you're representing whether the property is going to be their principal residence or not. Colorado law actually requires us to disclose that. I don't know why. I think that's stupid, but this is certainly helpful for lenders in the event that there's a lender involved. Okay. If this box is checked here, then the buyer and seller agree to execute a post-closing occupancy agreement. And again, if you're going to do that, then do it with the contract, right? We had one of the two cases that I was talking about had this box checked, and it said, yep, buyer and seller agree to execute a post-closing occupancy agreement. The buyer's agent was like, oh yeah, the buyers are super flexible. Sellers can have as long as they need to, right? And this was a phone call with the listing broker. Buyer's agent's like, yeah, they can have as long as they need to up to those 60 days, no problem. Everything's good to go. And they checked this box, but then they didn't do a post-closing occupancy agreement. And then a week prior to closing, they're like, okay, well, we should probably hammer out the terms of this post-closing occupancy agreement. The buyer's like, okay, yeah, that's fine. How much time do you need? And they're like, well, probably like 2 weeks. Buyer's like, okay, that's fine. We want a $5,000 security deposit, which there's no right or wrong, but that's crazy. Okay. So buyer wanted a $5,000 security deposit, and they wanted $250 per day. Well, $250 a day is way more than what the buyer is going to pay, depending on, how much they're financing and whatever else. But this is like a $300,000 property. There's no way it was costing the buyer $250 per day to hold this thing over. Okay. So, hammer it out up front, guys. It is not worth just letting it go and be an issue later. Okay. So let me pop back into screen sharing here. Any questions on section 17? Okay. 18, computation of days. So obviously day ends at 11:59 p.m. Now it is possible that you can alter that, right? If you go down to additional provisions and write a provision in there that says, in regards to section 18.1, day is going to end at 5 p.m. instead of 11:59 p.m. Okay, you can do that. I don't like changing it just because I've been doing this for so long, right? That I've gotten used to 11:59 p.m. and that way I'm not like, oh yeah, I'm gonna go eat dinner with my family and then I'll come back to this and fix it later, and then lo and behold, oh crap, 5 o'clock was our deadline on this deal. So unless it's specified otherwise, 11:59 p.m. is when your day ends. Okay. And then in computing a period of days when the ending date is not specified. So for instance, if you used MEC plus 4 days, let's say MEC plus 4 days. So today's the 13th. Then the way that we would calculate that is tomorrow, Wednesday, would be MEC plus 1. Thursday would be MEC plus 2. Friday would be MEC plus 3. Saturday would be MEC plus 4. But because that's a Saturday, right, we need to determine, is that going to be extended to the next day that is not a Saturday, Sunday, or a state or federal holiday. Okay. So there's no right or wrong here either. I typically check will not. And there's arguments for both. When I'm writing my contract, I just have a list of the state and federal holidays up. And I know that either I'm not going to write my deadlines on state or federal holidays. And in most cases, I'm also not writing them on Saturdays or Sundays. It's not wrong to do that. Even if you write it on a state or federal holiday, you can do that. And you may or may not want that to extend. So just know how this affects your deal. Particularly, it is important when it comes to the closing date, because what happens if you say, no, they're not going to be extended, and then turns out your closing day falls on a state or a federal holiday and you didn't realize it, right? Now, and let's say it's Memorial Day, right? Which it happens to be on a Monday. And so you're like gearing up for everything on Friday, and buyers are like, okay, we're gonna, get all of our stuff packed up over the weekend, and then we'll get it closed on Monday, and then, back to work on Tuesday. And then all of a sudden the buyers can't close because title's not open, or because their lender isn't funding the deal, or, whatever the circumstances are. Your buyer may end up in default if they can't get it closed because you said, no, it's not going to extend. So if you're not going to pay super close attention to when those are, then check the box that says they will, and know how that impacts your transaction. If you are paying attention, then check the will not box. If you don't want them to be extended, again, there's no right or wrong. Okay. If neither box is checked, it automatically defaults to will not be extended. Okay. Section 19. So this is the fun stuff. So this is like the what happens if, there's catastrophe or whatever. Okay. So first thing here, section 19 says the property and the inclusions, or both, will be delivered in the condition existing as of the date of the contract, with ordinary wear and tear accepted. Now, ordinary wear and tear accepted doesn't mean like, okay, we can rough it up a little bit. Like, just do everybody a favor and tell your sellers or tenants or whoever to transfer the property in better condition than the date of the contract, and then hopefully you shouldn't have any issues. Okay. But if there is some kind of damage to the property that happens after you go under contract, after the date of the contract, then what happens? Well, let's talk about 19.1 first. So if the property inclusions are damaged by fire, flood, other perils, whatever, some type of cause of loss, in an amount of not more than 10% of the total purchase price. So let's say $400,000 property, right? And there's approximately $30,000 worth of damage. Okay. This section is going to apply right now. And what it says is, if that repair of the damage will be paid by an insurance policy, right, other than the deductible, which would be paid by the seller, but if the damage is going to be covered by insurance, then the seller, upon receipt of those insurance proceeds, will use their best efforts to repair the property before the closing date. Okay, so they can't just drag it out. They need to try to get it done before the closing date, but it's not always possible. Okay, and in some cases, maybe the work gets done, but it's not up to the buyer's satisfaction. And so what it says is the buyer will have the right to terminate under 25.1 on or before the closing date if it's not repaired, or if the damage exceeds such sum, and that sum is 10%, right? And so if the work is not done, right, even if the insurance company has approved it, but the work is not done, then the buyer has the right to terminate, or if the work exceeds that 10%, the buyer can terminate all the way up until the closing date. Okay. Now, if the buyer elects to continue on with the contract and close it anyway, despite the damage, then the buyer is entitled to a credit at closing for the total amount of those insurance proceeds that were paid out by the insurance company, right? But not by the association. And so if there's a condo and the association is going to take care of some of the work, right, they don't get a credit for the work that the association is going to do. This is only the insurance. Okay, so they'll get a credit for the amount of the insurance proceeds resulting from the damage, plus the seller needs to pay the buyer the amount of the deductible from the insurance policy. Okay, because the seller would be paying that either way. So if it's $1,000 deductible, the seller needs to pay $1,000 to buyer. If it's $2,500, then that needs to be paid by the buyer, whatever. Okay, that credit, so the credit from the insurance proceeds plus the deductible cannot exceed the purchase price, right? Which is probably fairly uncommon, right? But it can't exceed the purchase price. If the seller has not received the insurance proceeds prior to closing, then they have some other options open to them as well. And so maybe the seller submits the insurance claim, the insurance adjuster comes out and looks at it and they say, okay, yeah, that's fine, we'll approve the claim. However, just because of the way that the insurance company works, right, in many cases, they will cut a check to the bank The bank has to sign off on it, and then they'll cut that to the seller, or they'll cut that directly to the contractor or whatever. Okay. And so in many cases, the seller may not actually have the total amount of those insurance proceeds to credit to the buyer. And so that's where this part comes in. And it says, if the buyer wants to do it anyway, but the seller doesn't have those proceeds, then the parties can do a few things. One, they can extend the closing date, which that's what I like to do if, you know, if that works for everybody, right? Because then we can say, hey, you know, we're just going to extend it until it's done. That way buyers don't have to mess with it. Sellers get it done all under their insurance policy, you know, everything else. It's probably the cleanest and easiest thing to do is to just extend the closing date. Okay. Or at the option of the buyer, so seller has no right to dictate this, this is up to the buyer. The seller must assign the proceeds from the insurance company to the buyer at closing. But what you have to know is that that has to be acceptable to the seller's insurance company and the buyer's lender. And really, it should also say, and the title company. The title company really shouldn't take any issue with this, but sometimes they want to hold 1.5 times the cost of repairs. And so that may also impact your deal, particularly if you have the seller, right? And let's say there's $30,000 worth of insurance proceeds, and seller says, okay, yeah, that's fine. You know, I will assign you, buyer, the right to my insurance proceeds. I've already talked to my insurance company. They're cool with it. Buyer, make sure your lender's cool with it. Lender says, yep, no problem. And title goes, well, we need to hold $45,000 back from the seller's proceeds until this work gets complete. Well, if title needs to hold $45,000 from your seller's proceeds, maybe your sellers have enough equity that that's not a problem. But what if they need that equity to put down as a down payment on another home? Then that's not going to work, right? And so it's important to check with both the insurance company, the lender, as well as the title company, okay? Or if they don't want to do that, then the parties can enter into a written agreement prepared by who?
Attorney.
Yeah, so technically the parties could prepare that agreement, right? Which is probably not advisable. And I think you're probably violating real estate commission rules if you're advising your clients to draft that, you know, that agreement, because you're supposed to recommend legal counsel for anything that is outside of the scope of your ability to do, right? Certainly if you're not able to do it, probably the parties are not able to do it either, okay? So really that agreement should be drafted by an attorney, okay? And basically what that agreement should do is require the seller to escrow from their proceeds, whatever amount that they have received and whatever amount they will receive, plus the amount of the deductible from the insurance policy, okay? Obviously that can't exceed the total purchase price either. So what questions do you guys have? This is one where we get a lot of calls as managing brokers, like, hey, what happens when this? What should I do in this case? Do you guys have any questions on this piece? Nothing? You guys are quiet today.
I think I'll just cross that bridge in the event that it happens.
Yeah, most people do. Okay, thanks. Okay, 19.2 talks about damage to the property. So inclusion services, any of that type of stuff. So if there is any damage, including, you know, utilities, cable, phone, internet, any of those types of systems, components, whatever, if they fail or are damaged between the date of the contract and closing or possession, whichever is earlier, right, then the seller is liable for repair or replacement of those items. Now, there is a provision that would override this, and that's if the buyer happens to damage it, right? Or if the buyer's vendors, like an inspector, if they damage the property, then they would be liable for it, okay? But if it's just something like, let's say the furnace goes out, for instance, it was working when the property went under contract and it fails prior to closing, then the seller would be liable unless you've got some other agreement written into the contract elsewhere, okay? So they need to repair that or replace it. And they must do it with a unit of similar size, age, and quality, or an equivalent credit. So that's all fine and good, but who gets to determine whether it's a unit of similar size, age, and quality, or an equivalent credit? Who determines that? You've got a house listed that was built in 1979, and it has the original furnace in it. And the furnace was working prior to closing. And lo and behold, 2 weeks prior to closing, the furnace goes out. So seller's going to go find a 1979 furnace. The original furnace in the house was still the one that was in there at the time it went under contract. Seller's going to go find a 1979 furnace and put it in the house. Does that sound like a good idea to anybody? Okay. So although there's a provision in here, it's really not perfect. Okay. And it wouldn't make sense to do that, right? It would still cost, a significant amount to install a 1979 furnace and remove the other one, right? So what's an equivalent credit? Well, does it have to equal the amount of a brand new furnace, or can it be somewhere less than that, right? I don't know. It's up to the parties to negotiate. So it is not a fix-all, but just know that if one of those things was damaged, seller needs to replace it with similar unit. It doesn't have to be brand new, or they can provide a similar, an equivalent credit. But that's very difficult to determine. And the buyer is always going to think the credit needs to be bigger. The seller is always going to think it needs to be smaller, right? So do your best, go advocate for your client, hope that the seller is reasonable. Or if you have a seller, hope that the buyer is reasonable. But this can create some serious issues, okay? So do your best. Certainly we're available to step in and help where we can, but just know that this is not a great provision, okay? Let's see. Obviously, if there's something that is broken that is the responsibility of the association, then the seller is not obligated to fix that. The association would be responsible to fix that. And then if it is not repaired or replaced on or before closing, which I was earlier, buyer can terminate on or before the closing date, right? That makes sense. If the furnace went out and it was working when you went under contract, buyer shouldn't be obligated to close on the property. Or at the option of the buyer is entitled to a credit at closing for repair or replacement of that. And again, it can't exceed the purchase price. It's got to be an equivalent credit, right? You can't just say, oh, that 1979 furnace, we're going to replace with a 95% efficient furnace that's brand new and it's oversized and, it's whatever. I'm not an HVAC person. I don't know all the terms, but you can't just pop them for the whole amount of that and expect that the seller is going to just have to say, okay, yeah, we'll do that. Okay. If the buyer receives that credit, then the seller's right for any claim against the association will survive. So again, if there's the association involved, then that's still it is going to survive closing, right? But the seller is not going to be obligated to make any repairs that the association is obligated to do. Okay. All right, condemnation. So hopefully you don't ever have a property that gets condemned as part of your transaction. However, the one that I could potentially see this being a case is typically if a property tests hot for extremely high levels of meth, right? Then a property could get condemned. The other thing you might run into is like if a car happens to drive through the property, which sounds crazy, but I have sold a property to a client where a car, I don't know if the lady was drunk or fell asleep or whatever, but she veered off the road through my client's fence and drove right into their front entryway. And it created structural damage and everything else. And so it wasn't permanently condemned, but they did have to get out of the property and leave until the work got completed. But if it was bad enough, the whole property could have just been condemned, right? So if there's some type of catastrophic damage, a tornado or whatever, you may end up dealing with condemnation. Really, the only other thing I could think of would be like if like a local government was expanding a road, right? And they were taking property along the road in order to widen the road. You know, there's a huge political debate associated with whether they should have the right to do that or not. Doesn't matter what side of the debate you're on, but just know it does happen. So it is possible to have condemnation where your property gets condemned. Hopefully you don't ever have to deal with it. But if the seller receives any notice stating the property is going to be condemned, then they have to notify the buyer, and then the buyer can obviously terminate on or before closing, or if the buyer elects to continue forward with the contract anyway, despite any diminution of value to the property, the buyer is entitled to a credit at closing for whatever the condemnation proceeds are going to be. But the credit will not include relocation benefits, expenses, anything else, and it can't exceed the purchase price. Okay. So feasibly, you know, you could, you know, have a property that gets condemned and you were under contract for $350 and you thought that, you know, you could take that $350 and go spend it elsewhere. Then you could still close on the property, get your $350,000, and then go buy some other property. Now, it's not going to work if there's a lender involved. The lender is not going to lend on a condemned property. Okay. So highly unlikely we're going to have to deal with that. If for whatever reason you do, call me, but unlikely you'll ever deal with that. Okay. All right. So walkthrough and verification of the condition. So buyer upon reasonable notice. Where is reasonable notice defined in our contract?
It's not defined.
It is not defined. Thank you. Do you know how we know it's not defined? It's not capitalized. Okay. If it's capitalized, other than being at the beginning of a sentence, if it's capitalized, it's a defined term. If it's not capitalized, it is not defined anywhere. So who gets to determine what reasonable notice means? I have no idea, right? Do your best, be nice to the other party. Hope they let you in. Okay. But upon reasonable notice, they have a right to do a walkthrough prior to closing to verify that the physical condition of the property and the inclusions complies with the contract. Now, what I'll tell you is, and this is what Damien, who is our brokerage firm attorney, what he recommends is you should probably really do multiple walkthroughs. Okay. So particularly if you have an inspection objection where there was a resolution for things to be repaired or fixed or replaced or whatever. Okay. You should probably do a walkthrough maybe like a week to 10 days prior to closing, right? And on your inspection resolution, I guess the important piece before we even get there, on your inspection resolution, you shouldn't just say that those repairs need to be complete by closing. Okay. Because what happens if you say, oh, those repairs are going to be complete by closing, and you go there the morning of closing and they took a stab at it, right? They gave it the old college try, but the repairs are really not up to the buyer's satisfaction. Well, now you have an hour before closing and the buyer's not satisfied with the repairs, but they're pulling up in their moving truck that's fully loaded with all their stuff. What are they supposed to do? Right? At least if you have those inspection resolution items repaired maybe a week or 10 days prior to closing or something like that, then you can go and you can verify, do a walkthrough that week or 10 days prior to closing. And then at least you've got some wiggle room to try to get things situated on your buyer's side, right? So that they're not showing up to do their final walkthrough in their closing truck with all their crap. And now they don't have an option but to close on the property. Okay. So Damien says, make those repairs due a week, 10 days, 2 weeks, whatever it is, but in advance of your final walkthrough, and then go verify that they got done to your buyer's satisfaction, and then do another walkthrough the morning of closing to make sure that the property didn't flood or that the sellers didn't drop their piano down the stairs while they were moving out or whatever, right? And so probably a good idea to do multiple walkthroughs, okay? Home warranty, this section got added the last time the contract was revised, and it just basically says buyer and seller are aware that home warranty programs are a thing. If they want one, they can go see what it costs to get one. Okay. Recommendation of the legal and tax counsel. You guys know you know, don't be the cheap free legal advice. If there's something that's outside the scope of real estate brokerage, send them to an attorney, right? I know everybody wants to be like super helpful to their clients and you know, take on all these extra duties that they don't have to, and they want to go above and beyond and all that stuff. And I understand the sentiment, and at the same time, I've seen the results of doing that. Okay, so be a great real estate broker, take on those duties and do them well, right? And if it's beyond the scope of real estate brokerage, refer them to an attorney or a CPA or somebody else who is competent with whatever it is that you're dealing with. Okay. And so one of the things that I want you guys to know is that there are times when you call me and I'm a little bit guarded with my response to you. And it's not because I don't know, I haven't been through the process before. In some cases it is, guys. I don't know everything, but there's some cases where I could tell you how to fix it, but if I did, I know you're going to go tell your client and you're probably putting yourself in jeopardy, right? And so perfect example, I had a broker call me, and this was post-closing occupancy agreements are the devil. Okay. If you want to know my opinion, that I'll just say that. Okay. So I had a broker call me and he said, hey, there's a tenant that lives in the property, right? And we're going to close on April 15th, let's say, but the tenant's lease goes through the end of April, right? And we don't want to have to deal with assigning the leases and assigning security deposits and all of this other stuff. So why don't I just write the contract where we close on April 15th and then the buyer gets possession on April 30th, and then we'll do the post-closing occupancy agreement for those 15 days. Well, what's the problem with doing that?
You've got a third party involved.
Yeah, who are the parties to the post-closing occupancy agreement?
Buyer and seller.
Yeah, buyer and seller, not the tenants, right? And so doing a post-closing occupancy agreement that says the seller can retain possession of the property and the seller has all of these obligations, it doesn't work, right? And he wanted me to give him verbiage as to here's what you should put in the post-closing occupancy agreement to make it work for a tenant occupied property situation, right? That there is not a good option that a real estate broker should take if that's the case. What you should do is assign the leases, assign the security deposits, or move closing, right? And he kept pressing me on it, like, hey, what should I do? How do I fix this? Like, I don't want to talk to an attorney. I don't want to deal with, doing these, but I got to close by the 15th. Can't close by the, can't extend closing to the 30th. It's like, I don't know what to tell you, right? Like, I'm not going to give you advice on something that you shouldn't be given advice on, okay? So just know that there are some times where I will be a little bit guarded because I don't want you to go take what I say and then transfer that to your clients and then say, oh, this is what Jesse told me to do, right? I'm not going to put myself in that position. You guys shouldn't put yourself in that position either, okay? All right, time is of the essence, default and remedy. So time is of the essence. And effectively what that means is that our dates and deadlines in our contract, they have meaning, they have weight, they are strict, they are absolute. If you miss one of those deadlines, right, there's no grace period, okay? So when you go under contract on a property, I don't care whether you're buyer or seller side, put those deadlines wherever it is that you're going to see them, right? I have my TC add every single one of my dates and deadlines into my Google Calendar with reminders 24 hours in advance, right? So that I see, hey, this deadline is coming up tomorrow. Are we where we need to be, or do we need to try to get an amendment going? Do we need to terminate? Are we okay, blowing past this deadline, right? But put it somewhere where you're going to see it. If you use a planner, write them all down in your planner. If you use Google Calendar or whatever other calendar option, put it in there so that you're going to see it. Because if you miss it, it has consequences. Okay. If any payment due, including the earnest money, is not paid, honored, or tendered when it's due, or if any obligation is not performed timely as provided in the contract, the non-defaulting party has the following remedies. Effectively, what this says particularly in relation to the earnest money, is that if the earnest money is not paid when it's due, the buyer is in default per the terms of the contract. Okay. So if the buyer is in default per the terms of the contract, what are the seller's remedies?
Well,
What
he's
is
probably
this?
going to keep the earnest money.
Okay, so we have a couple of potential options, right? And one of them is hopefully never an option when you have the buyer. Okay, and so if we go back to the contract, right? If this box in 21.1.1 is checked, then seller has the option to do specific performance or liquidated damages or both. Okay. Damages are things like attorney's fees. And hey, I had to change my plans and that cost me X number of dollars and it screwed all this other stuff up, court costs, all these other things. Okay. And so unless you have an extremely sophisticated and deep pocketed buyer, I really don't ever want you guys to check this specific performance box. And if you feel like it's a good idea for some reason, tell your buyer to go talk to an attorney. Okay. Is it possible to make your contract more competitive by doing that? Yes, it is. Okay. But this is not something that first-time home buyers should be doing. Okay. I'm going to leave it at that. So if this box is not checked, right, then what is the seller's remedy? Well, the remedy is liquidated damages, right? And so the seller can elect to cancel this contract. All earnest money, whether it's been paid by the buyer or not, doesn't matter, will be paid to the seller and retained by the seller. So just because a buyer doesn't get the earnest money delivered when they're supposed to, doesn't mean that they have no skin in the game, right? Simply by missing the earnest money, the alternative earnest money deadline, the buyer is now in default. The seller can cancel the contract and they can pursue the buyer for the earnest money and keep their earnest money, which hasn't even been paid yet. Okay. So don't miss that earnest money deadline. A lot of people, what they do when they're writing their contract, right, is they'll say, okay, I need my alternative earnest money deadline to be 3 days out, right? And so today's Tuesday, they say 3 days out, we'll make this Friday, right? And so they'll put in Friday, April 16th as their deadline, but then they're given the buyer or they're given the seller until like Saturday or Sunday to accept the offer. So the seller, signs the contract. They say, hey, we really like your offer. We're just going to sign it as you wrote it, right? And on Sunday night, they deliver a fully executed contract to you, and you had a hard deadline in here of April 16th, which was Friday. Well, guess what? Your buyer's in default, and they don't even know that they're under contract yet. Okay, so while I do use hard dates and deadlines, I know I've written MEC deadlines in here, but that's really just to give you an idea of like a plain vanilla 30-day, right? Like these are roughly how far out these deadlines should be in most cases, but not all, right? While I will typically use hard deadlines in place of these MEC deadlines, this is the one that I almost always use an MEC deadline for instead of a hard date. And the reason for that is sometimes there's negotiations that take a couple of days before you actually get under contract, right? Buyer might hit you up after the fact, or they send you a counter and you're buried in the counter and you're thinking like, okay, yeah, they countered us on price and they countered us on inclusions and whatever else. And you're like, yep, that's all acceptable. The buyer, you go to sign it and you didn't look at that alternative earnest money deadline. Okay. So typically what I'll do is I'll put that MEC plus 3 business days. That way I know I've got, at least 3 days or 2 or whatever you put in there to get that earnest money delivered to title or the brokerage that's holding it or whatever. Okay. Let's see. So it's agreed that the earnest money specified in section 4.1 is liquidated damages and it's not a penalty. The parties agree that that amount is fair and reasonable. And that it's the seller's only remedy for the buyer's failure to perform their obligations under the contract. seller waives their remedy of specific performance and additional damages. Okay. So I'll give you some advanced like contract strategy stuff right now. Okay. So in a competitive market, how many of you guys have had buyers who they went way over list price on their offer and they say, hey, we're like, let's say it's listed at 400. Buyer goes in at 450 and they say, if it doesn't appraise, we'll do $10,000, whatever it appraises for. So you've got that $10,000 appraisal gap in there. And the seller still says, nope, we're not going to take it. We got a better offer. You've been beat out by offers with full appraisal gaps, right? It's extremely risky to do because you don't know what it's going to appraise for. It may not even appraise for 400. What if it appraises for 375, right? And you had a full appraisal gap up to 450. Now your client's on the hook for 475, okay? Well, if the seller's only remedy is the buyer's earnest money, okay, effectively what you can do is you can do a full appraisal gap clause and do your best to minimize the amount of the earnest money. Don't make it a specific performance contract, right? So that the seller's only option is your buyer's earnest money. So instead of say a $5,000 security or earnest money deposit, maybe you do $1,000 earnest money deposit, write a full appraisal gap, right? You're going to guarantee the full appraised amount, okay, which you actually don't need a clause for. I'll talk about that in a minute. Knowing that your buyer probably can't actually perform the terms of that contract, or they may not want to. What's the buyer's what's the buyer's damage if they walk away from that deal because of a low appraisal?
$1,000.
$1,000. Is it worth it to get their foot in the door? Potentially. Now, a couple things you need to keep in mind. One is we have an obligation to disclose adverse material facts, including adverse material facts about a buyer's financial situation. Okay. Another thing is, going back to that appraisal gap, if you have a buyer who wants to make that competitive an offer where they do not want to put a cap on their appraisal, their appraisal guarantee, you don't need to write any language into the contract in additional provisions. How would you do that in a contract?
You just waive appraisal.
Yeah, you waive the appraisal. It doesn't mean that the buyer has to, it doesn't mean that the buyer doesn't need to get an appraisal. It just means that they are waiving their appraisal contingency, meaning they have no right to terminate based on the appraisal. And if they do terminate because of the appraisal, then they're in default, right? So you don't need to write, again, if you are capping your appraisal guarantee at 10,000 or 20,000 or whatever, yeah, that's a provision that needs to be written into additional provisions. If you've got a buyer who's willing to just say, hey, I don't care what the difference is, I'm going to pay it, you don't have to write anything into additional provisions. You simply waive your appraisal deadlines. Now, you may want to write something in additional provisions that says something to the effect of, seller agrees to cooperate with letting the appraiser into the property to do the appraisal, right? But you don't need a provision to terminate based on a low appraisal. So you simply waive your appraisal deadlines. Okay. Know that that is extremely risky. And if I were going to do that with a buyer, I would absolutely put in writing, in an email, or when you send the contract to them through DocuSign or CTM or whatever, right? Hey, I just want you to know, you've agreed to bring the full amount, the full gap between the appraised value and the purchase price. We don't know what that's going to be, right? And if you do terminate or, whatever, then your damages are going to be your earnest money. You will lose your earnest money. Is that something you're willing to do to try to get your foot in the door? Okay. And if you can negotiate a lower earnest money amount, and the seller's dumb enough to bite on it, then great. Roll the dice, see what happens, right? And the other thing that I would tell you from a strategy perspective is have that appraisal happen way out in the future, right? You've already waived your right to terminate based on the appraisal. So I'm going to tie the seller up for as long as I can, get as close to closing as I can, so that hopefully they have no additional, or so that hopefully they've made additional plans, right, as far as moving or whatever else. And now they're in a position where they can't start over from day one. Right? Does that make sense to everybody? Okay. So what happens if the seller's in default? Well, the seller doesn't pay any earnest money, right? So there is no liquidated damages option. If the seller is in default, the buyer can elect to treat this contract as canceled, in which case they will receive their earnest money back, and the buyer can recover such damages as may be proper. They can also elect to treat the contract as being in full force and effect, and they have a right to specific performance damages or both. Okay. Again, that could be extremely costly. And so, you know, there's been some sellers who have said, hey, you know, I'm having a really tough time locating a replacement property. And so I've just decided I'm not going to sell it to the buyers. Well, do they have a right to do that in the contract? I mean, maybe you've written a provision into the contract which would allow that, but short of you writing a provision into the contract that would allow that, no, the standard contract doesn't allow for a seller to just say, no, I'm going to, you know, terminate the contract because I can't find a replacement property. Right? So seller has very, very few outs to terminate a contract. Most of them are associated with, you know, short sale, foreclosure, you know, stuff having to do with private seller financing, right? And most of those are just not going to apply in your typical deal. So seller has very few rights to terminate. And if for whatever reason they feel like they do have a right, or that's what they want to do, then you need to send them to an attorney. Okay. It could get extremely costly if they just say, nope, I'm not going to do it. And you go, okay, well, I guess I'll just let it ride out and we'll see what happens. And nope, as soon as they tell you that, it's time for them to talk to an attorney. And I would absolutely advise them in writing to do that. Okay. Legal fees, costs, and expenses. So, you know, anything to the contrary here notwithstanding, if there's any arbitration or litigation relating to the contract, then the court must award to the prevailing party any reasonable costs and expenses, including attorney's fees, legal fees, and so on, right? And unfortunately, what I'll tell you is, even though it's very black and white in our contract that the prevailing party will be awarded their legal fees and court costs and everything else, in many, many cases, the legal fees get reassigned to whichever party they were associated with, right? And the reason for that is you go through a lawsuit, right? And the judge makes their decision and they say, hey, based on the merits of the case, seller, you're in the right here, buyer, you're in the wrong. And then eventually what probably will get negotiated is the buyer and the buyer's attorney and seller's attorney will get together and they'll say, hey, we're going to modify, the buyer's attorney will say, we're going to modify our complaint and refile against the seller, or you can agree that we don't have to take on your legal costs and we'll just drop it right here. Okay. And so there's this stupid negotiation at the end that you know, buyer's attorney and seller's attorney do. And it doesn't always happen that way, but just know that it is very common that even if you are the prevailing party, your legal fees may be assigned back to you to pay via a negotiated agreement between you and the buyer. Okay. So even if you think you have a good case, it's not a good idea to advise your client to go to court unless they really just understand what they're getting into, unless they've been properly advised by an attorney, right? But I don't want you guys doing that and threatening lawsuits and, you know, advising your client that, hey, you'll have your legal fees paid for, assuming we win this thing or what. No, it doesn't always happen that way. Okay. All right. Mediation. So keep in mind, this is the contract between the buyer and the seller. So if there is a dispute, that, that relates to the buyer and the seller, not between you and your client, right? There's a mediation clause in our exclusive right to buy or our exclusive right to sell. It's very similar, right? But this is between the buyer and the seller. So if there's a dispute that arises from this contract and it's not resolved, the parties must first proceed in good faith to mediation. Okay. Now, what I'll tell you is, anytime that mediation, becomes a thing, what happens is one party typically sends a demand for mediation letter to the other party. And then it says, hey, we demand your presence at mediation. We need to try to determine an acceptable mediator and a venue and all this other stuff, right? And in some cases, it's impossible for the parties to agree on an appropriate mediator and a venue and everything else, okay? And so if 30 days elapse from the date that demand for mediation letter has been originated and you still haven't elected, or selected a mediator between the parties, it can proceed straight to court without ever having gone to mediation. Now, it's up to the judge whether they want to see that case. They might kick it back to you and go, well, you didn't in good faith actually try to go to mediation. You just sent the demand letter and then you delayed until 30 days. And then now you're wasting my time having never tried to actually mediate the problem. Okay. But other judges might actually take it up, or there may be a legitimate reason why you couldn't select an appropriate mediator within those 30 days or whatever. Okay. At mediation, a mediator cannot impose a binding decision. So even if the mediator thinks, hey, buyer, you're 100% in the right here, the mediator cannot force the seller to make it right. They can't force the seller to do anything, okay? If the parties agree to it in writing, then that's fine, but otherwise the mediator cannot force it, okay? So the parties need to jointly appoint that mediator, and they will share equally in the cost of mediation. Typically costs a couple $1,000s to properly mediate a deal, okay? The obligation to mediate will terminate if it's not resolved within that 30-day period. So it's also possible to actually appoint a mediator, go to mediation, and the parties just don't agree on a resolution. So if it's not resolved in 30 days, then the obligation to mediate goes away as well, and then it can proceed to court, okay? Nothing in this section prohibits either party from filing a lawsuit against the property. That's okay, but as brokers, you should never file a lawsuit or a lis pendens. That should always be done in conjunction with an attorney, so don't ever try to do that yourself. You, as brokers, can't record contracts or anything like that, okay? All right, earnest money dispute. So if earnest money disputes are more common than they should be, in most cases, it's because you have a hard-headed seller and you maybe didn't fully advise them properly with regards to what rights they have to keep the earnest money, right? And so typically the way that we see this happen is, buyer gets to their new loan termination deadline and they go, hey, we're not quite where we need to be, or interest rates went up, or we don't like our closing costs, or whatever it is. And so we're going to terminate. Well, in most cases, your new loan termination deadline is like 3 or 4 days prior to closing. And at that point, the seller's got everything packed up. They may be already out of the house. They've moved on to their next home or whatever it is. And you're telling me the buyer has a right to terminate the contract and get their earnest money back, meaning the seller has nothing to show for it? Okay. It's painful to be a seller in that position. But if that's what you've agreed to as far as your dates and deadlines, then that's those are the consequences, right? If they don't want to get stuck 3 days prior to closing, then don't give the buyer the new loan termination deadline 3 days prior to closing. Okay. So that's typically why we see them. But in most cases, it's usually pretty clear cut as to, who has a right to the earnest money. but there's hard-headed buyers and sellers out there. And regardless of how well you've done at advising them, they still think that they're right, or they just want to make it difficult or whatever else. Okay. So the earnest money holder has to release that earnest money following receipt of written mutual instructions signed by both parties, the buyer and the seller. Okay. But if there is some type of controversy regarding that earnest money, then the earnest money holder has several options available to them. One is they can just sit on it forever until there's some type of written agreement between the buyer and the seller. Two, they can interplead the parties and deposit the earnest money into a court of competent jurisdiction, which basically just means they can say, okay, buyer, seller, I'm giving it to the court and you guys go deal with the court. I'm out. Okay. They can provide notice to buyer seller that unless they receive some kind of written, summons or complaint or whoever the court is that's dealing with it within 120 days, then the earnest money holder will return the earnest money to the buyer. And that is the option that most earnest money holders, title companies, most brokerages, that's kind of the option that they take is option number 3. They say, hey, if you've notified us of an earnest money dispute, but you haven't notified us of any resolution within 120 days, then I'm just giving it back to the buyer unless I have something from a court telling me to either continue holding it or to distribute it to the seller or some other agreement. Okay. Any questions on that piece? Anybody had an earnest money dispute in here? Brandy, did I help you with that one?
Yeah, it was a while ago. My buyers had a lender that was, oh gosh, it was like Veterans of America or something. And the lender failed to disclose to the buyer that the loan was contingent upon him paying off an auto loan. And so the loan termination deadline came up and it was like, nope, we don't have clear to close because you need to pay this off. And we're like, what just happened? And the deal fell apart and seller didn't want to release the earnest money. And it was like, well, you can't buy it. So what do you want?
Did we get it back?
Yeah, but it went to the full.
Oh, you muted yourself. Brandy, you muted yourself.
It wasn't even held with a title company. It was held with the actual agency.
Okay.
The brokerage. And so we didn't get the earnest money back until the house went back under contract with another buyer. So,
okay. Yeah. And that's fairly common. Sometimes if it's held by a brokerage, what they'll do is they will hold it until they go back under contract. And the reason that they release it at that point is if they're still holding on to the earnest money, they're effectively saying, buyer, you terminated you terminated for a reason under which you had no right to terminate, or in other words, you should really still be under contract, right? And so it's hard for you to argue that I'm going to keep your earnest money when I said you had no right to terminate and you should still be under contract. And so once they have another acceptable offer, they'll say, okay, fine, now I'll release it because now I'm agreeing that, you had a right to terminate, even though they wanted to fight you in the beginning. Really what they want to do is go back under contract. And you should never go under contract when you have unresolved earnest money unless and until the buyer has passed the closing date. Okay. So, if today's, April 13th, right, and you're supposed to close on April 30th, and you get to April 15th and the buyer terminates and the seller says, nope, I think you're full of crap. I think you just found another house that you like better. You had no right to terminate for that. So no, we're not going to release your earnest money. Well, the seller shouldn't be taking another offer until May 1st, right? Because they've effectively said, buyer, we think you had no right to terminate. And so our deal should theoretically still be under contract. And so until you miss that closing date, the buyer's probably not in default, right? Once they past that, well, now they've missed that. Now they have not closed on the property like they were supposed to. And it would be very difficult for the buyer to ever come back and say, hey, I still had rights under that contract. Okay. Let's see here. So termination. So if a party has a right to terminate, okay, and this is, I'll tell you guys, there is disagreement in the legal community as to effective termination. I'm not going to go into depth, okay, but I will even tell you that Damien, who is our brokerage firm attorney, and Scott Peterson, who many of you guys know, he represents the Colorado Association of Realtors. Damien and Scott are like besties. It's kind of cute. But anyway, they are good friends. They collaborate on a lot of things. They agree on like 99% of things from a legal opinion perspective. But there's even disagreement between Damien and Scott Peterson in regards to effective termination. So I'm going to leave it at that. But effectively what this says is if the party has a right to terminate and the termination, then the termination is effective upon the other party's receipt of the written notice to terminate, provided it was received on or before the applicable deadline. Okay. So just kind of breaking it down a little bit, effectively it's just saying, let's say from a buyer's perspective, right? I had a right to terminate, and so I did terminate prior to my deadline. Therefore, the termination is effective upon your receipt of my written notice to terminate. Okay. So does that mean that the deal has truly died and been resolved at that point? And this is where there's disagreement. Okay. And I'm just going to leave it at that. But if the notice to terminate is not received on or before that deadline, the party with the right to terminate accepts the specified matter, meaning if you don't terminate on or before your deadline, you're moving forward. You lost your right to terminate. You've accepted it as it is, right? And you're moving forward, okay? And then as far as the effect of the termination, in the event that the contract is terminated, which again, we're kind of referring back up here, but it's not capitalized, so it's not technically a defined term, right? If the contract is terminated, then all the earnest money received hereunder will be returned to the buyer and the parties will be relieved of any obligations subject to all of these sections, right? Particularly with regards to an earnest money dispute. Okay. So again, I don't want to wade into too much legal crap and why there's disagreement there, but if what I do want you to know is if you're going to terminate, then A, you need to have a right to terminate, meaning you have to terminate for the reason that you specified. You can't use the new loan termination for an appraisal, right? You can't use the appraisal termination for inspections. You can't use, new loan termination because you didn't check out the property insurance requirements and it turns out it's in a flood zone, okay? You have to use it for what it is specified for, and you have to terminate on or before that applicable deadline in order for it to be effective. Okay. Section 26. So this talks about this is this contract is the entire agreement along with any addenda, right? And any oral or written agreements have been merged and integrated into this contract. If they haven't, then they don't exist, right? Any future modifications will require, that it be signed by both parties in order for it to be enforceable. This is just all the legal crap, guys. Same thing with physical delivery notice, right? Obviously, physical delivery is fine. Electronic notice is fine. A lot of people will write in the blank here. They'll put DocuSign or CTME or whatever, right? You probably don't need to put that. Email is probably sufficient. Electronic notice is sufficient. Doesn't hurt to put it in there either, okay? Electronic delivery. So if those documents are delivered, they need to be delivered to the email at the email address of the recipient or at a link or access website, whatever, in order for them to be binding, or at a fax, at the recipient's fax number. So I typically will not put any fax numbers down in my section, right, where it has my brokerage info. I don't want any fax info in here because I don't want to be responsible for receiving faxes as notice of, you know, physical delivery or electronic delivery or anything else. And the other thing that I'll tell you guys real quick while we're talking about it is I never put in the buyer's information, their address, their phone number, their fax number, their email address, because what are you doing when you're putting this in here and then you're delivering the offer to the listing broker? Like, that's a terrible idea. And maybe the listing broker doesn't actually do anything with that information, or at least maybe they don't do anything with it during the course of the transaction. But as soon as it closes, guess who they can start marketing to? Your client. Okay. So I don't put any of their info in my contracts. I take all that out. Obviously, I put my phone number and my email address in there, but I don't put a fax number in there because I don't want anything to be faxed to me. Okay. Choice of law. So if there was a dispute that arises out from this contract, assuming this is the contract that is used, then it would be settled under, you know, in accordance with the state of Colorado's laws. Okay. Notice of acceptance and counterpart. So this proposal, meaning your contract, expires, or your offer, I should say, expires unless it's accepted in writing by both parties as evidenced by the signatures below, and the offering party receives notice of acceptance pursuant to section 27, which is physical delivery, electronic delivery, whatever, right? On or before that acceptance deadline date at the acceptance deadline time. Okay. Now, is there an obligation for a seller to respond by your acceptance deadline? What do you guys think? Does the seller have to respond by your acceptance deadline?
No, we do not.
Correct. There is no obligation for a seller to respond by the acceptance deadline. If they don't, all it means is that you don't have a deal. Okay. Now you can always put that deal together later, but it means that you don't have a deal. And so for people who think that like the seller has some kind of obligation to respond to the offer by the acceptance deadline or the parties in default, let's just get stupid about it, right? And I'll give you a really, you know, a perfect example. It's 10:27 right now, and I write up an offer and I say, hey, Susie, here's an offer for your listing at 123 Main Street. Our acceptance deadline is 10:30 this morning. You and your sellers are obligated to respond by my acceptance deadline of 10:30. Are they going to be able to do that?
No.
No, right? So you know, if somebody wants to tell you like, hey, you're in default because you didn't present the contract by my acceptance deadline or whatever else, no, you're not. Right now, you should present the offer to the seller at your first reasonable opportunity, but that doesn't mean that you have an obligation to respond or the parties are in default or anything else. All it means is that you have no contract, okay? If it is accepted, then this document becomes a contract between the buyer and seller. The contract must be executed by each party. They can each execute their own copy, right? Buyer can sign one version, seller can sign another version. As long as they're exactly the same, then we can add those two together and that becomes a full and complete contract, okay?
Hey, Jesse,
Yep.
I have a quick question. So let's say you do submit an offer and it goes past the deadline of the acceptance date in time for the seller. That buyer now is no longer obligated and can move elsewhere, but also the seller can counter back with updated dates. And then if that counter is signed by the buyers, then that contract now is valid?
Correct. Yes. So even if it has expired, right, you can write a counter offer that you don't need to rewrite the whole new contract. You just write a counter offer, and in the counter offer, you're going to put a new acceptance deadline date and time of, you know, today at 5 p.m. or whatever, you know, whatever time works for all parties to sign. And then, yes, you can just put the deal together that way without having to rewrite the entire contract.
Okay, thank you.
Yep. The other thing I'll tell you is really the buyer is not obligated to purchase through their acceptance deadline. And I don't want you to twist what I'm saying. All I'm saying is the buyer has a right to withdraw prior to acceptance, right? And so if I write an offer on your listing that says, hey, Susie, you know, today's Tuesday, the 13th, our acceptance deadline is tomorrow, the 14th at 5 p.m. Well, as long as I have not received acceptance of the offer, let's say tomorrow at 10 o'clock in the morning, the buyers are like, whoa, there's another property that hit the market that's perfect for us. We want to go pursue that one instead. I just have to send you something in writing that says, hey, Susie, I'm really sorry. I know our acceptance deadline was, you know, 5 o'clock p.m. tomorrow, you know, or if we're having this conversation tomorrow at 10 a.m., right? I know, you know, our acceptance deadline was today at 5 p.m. I'm really sorry, but buyers have elected to withdraw their offer. You know, best of luck to you, right? There's no form for that, but as long as you document it, it's in writing, you've withdrawn their offer, that they are not obligated to stick it out until tomorrow at 5 p.m. But if they do receive acceptance before that time, then they can't just cancel it. Okay.
Okay, and so that's just done via email.
Yeah.
Okay.
Yeah. I mean, you could theoretically do it via text, but text messages can disappear and hard to have the paper trail. So I absolutely would advise doing it, you know, via email if you can. Okay. And if you do it via text, like make sure you screenshot it and email it to yourself or whatever, so that you have that paper trail. Okay.
And then just to cover, you know, CYA, would you have the buyers send you an email stating that that's their wishes and their desires?
It certainly doesn't hurt, but at the same time, if they haven't directed me to do it, then I wouldn't be doing it in the first place.
Yeah.
Right. Okay. Let's see, good faith. So buyer and seller agree that, you know, each party has an obligation to act in good faith, including but not limited to exercising the rights set forth in these provisions, right? Financing, title insurance, record title, all these other provisions in our contract. And, you know, just because these get listed here, that doesn't mean that they have the right to operate in bad faith outside of these particular provisions, right? It's including but not limited to these provisions. So bottom line, they have to act in good faith. And effectively what that means is, you know, if I terminate, it's because I have a legitimate, you know, concern or you know, issue with whatever it is that I have objected to or terminated over, right? And, you know, there's some issues where maybe sellers intentionally try to sabotage a deal because they got a better backup offer or something like that, right? That's in bad faith. And so it doesn't just have to do with the buyer, right? There are times when the seller may feel like they are entitled to do certain things that they really shouldn't do. And so perfect example was under the old rules with respect to the lead-based paint disclosure, right? What a seller would do is they would sign the offer first, and then they would sign the lead-based paint disclosure immediately after that. Well, under the old rules, which we don't operate under anymore, so don't get confused here, but under the old rules, that meant that offer or that contract was void, right? Not voidable, it was void. It was as if it never existed. Okay. But then what would happen is the you know, even though it was a void contract, the buyer and seller acted as if they were under contract, right? Buyer would do their inspections, they would do their appraisal, and then, you know, lo and behold, the seller gets a backup offer for the extra $10,000. And then the seller goes, hey, buyer, really sorry to do this to you, but we have a void contract, meaning this contract never existed. And so I'm going to go ahead, terminate your contract. I'll give you your earnest money back, but I'm moving on to the next guy. Okay. And courts have actually ruled no, even though you had a void contract, you had an implied contract, which I don't even want to get into logistics and stuff there. But because you were both operating under an implied contract, we are holding the parties to the rights associated with the contract. And seller, you acted in bad faith by doing, you know, what you did. And so we are awarding, you know, damages to the buyer or whatever. Okay. Additional provisions, you'll notice that the section is blank. It is blank for a reason. I typically do an additional provisions class right after this class. But let's see. I'm going to be doing an additional provisions class for some of the offices in Colorado Springs on the 19th. And it's going to be a little bit updated, and it's going to have to do with some of the competitive, competitive market provisions that agents are using with respect to appraisal gaps and inspections and all these other things, right? And even though we talked about those a little bit, we're going to hit those a little bit more in depth. And so I may not do the additional provisions class next Tuesday. I don't know I'm going to send out an email to everybody. How's that? But if you have time on your calendar, put it on for, let me look at something here. Oh crap. Hold on. I think it's 2 to 4 p.m. So on the 19th from 2 to 4 p.m. If you have that available, block it out, because I'll be doing a little bit of an updated additional provisions class. And we'll probably invite all of our offices to it as well. And then the Colorado Springs offices will be on there also. Okay. So not going to get too deep into additional provisions. Just know it's blank for a reason. Anything that, is written into here, it is not approved by the Real Estate Commission. Okay.
That's Monday, right?
Monday the 19th. Yeah.
Okay.
And it's 2 to 4. So I know that kind of screws up. If you guys have other, I guess I'll ask while we're here. Is there anyone who knows that they have a conflict that they cannot make during that time, Monday from 2 to 4 p.m., the 19th? Jessica? Okay.
I could watch a recording though after, so.
Yeah, so it will be recorded for sure. And then, yeah, Brandy, so yes, we can record it. I don't want to, if we have an opportunity to do it, I don't want to do it and then also do it the following day for one person. So yeah, yes, it will be recorded, and probably then we'll move on to the next topic for contracts class next
And
week.
if you email me, I will add you to that list because I always send them out. So
yeah. And if you guys just want like the weekly email from Harry, just contact him. I send even for these recordings every week, I send him the link and then he'll just blast them out. It does take me sometimes a day or two to get the recording out to Harry, so it's not always immediate, and I apologize for that, but I do always get it to him. Okay. Let's see, we got one more chat here. Yeah, almost as old as Harry. So all right, other documents. So if the post-closing occupancy box is checked up in section 17 that we talked about, then that becomes a part of the contract. Any other documents that you list here are part of the contract, guys. I don't write anything in here. You can write in technically an addendum is a part of the contract. So source of water addendum, those types of things, whereas the disclosures are not typically a part of the contract. But does anyone care whether the source of water addendum is a part of the contract or not? Probably not. Harry, we just had somebody chat in and say, what's your info? So Harry, if you want to pop in there and don't just send it to me, pop in your email there, and we'll take care of that. So yeah, bottom line, guys, I don't write anything in here. Doesn't matter to me whether the source of water addendum is part of the contract or not, right? I still get it signed and everything else. And, people are like, well, should the closing instructions go in 31.1.1 or should they go in 31.2, right? I don't care. I don't even care if you write them in there, okay? And then obviously you've got buyers' names. Like I said, I remove all of their contact info because I don't want that going to the other broker. Make sure that you get the dates in there. And then for the broker's acknowledgements, you guys need to make sure you're filling out these boxes when you're completing your offer. So either you do or do not acknowledge receipt of the earnest money deposit. Are you working with your client as an agent or a transaction broker? even if this is a change of status, you still have to do a change of status form if you were representing, let's say, the seller as an agent, and then you pick up a buyer and you're going to represent both now as a transaction broker. So you can't just check this box and allow this to stand. You still need to do a change of status. Okay. If you are representing a seller and you pick up a buyer and you're still going to treat the seller as a seller's agent, you have to treat the buyer as a customer, right? You can't be a seller's agent for the seller and a buyer's agent for the buyer. You can't be a seller's agent for the seller and a transaction broker for the buyer. So if you're a seller's agent for the seller, your option is treat the buyer as a customer or switch into transaction brokerage for both. If you're going to treat the buyer as a customer, then you check this box here, right? Saying, I don't have a brokerage relationship with you. You should still give them a brokerage disclosure to buyer. You have to. Brokerage disclosure to buyer, and that will also say customer in there, okay? And then you check this box, and then you do actually sign, even though you're treating the buyer as a customer and you have no brokerage relationship with them, you would still sign as the broker, but your relationship is customer, okay? Who's going to pay your commission? Most of the time it's going to be the listing brokerage firm. Sometimes there's a split between, you know, let's say that you have an agreement with your buyer whereby the buyer is obligated to pay. And let's say that, you know, buyer's obligated to pay, let's say 3%, and the listing broker is offering 2%, and buyer says, yeah, that's fine. I want you to get paid what you're worth. I'm going to kick in the extra, you know, 1%. You could check both boxes there. That's okay. And then you should fill out all this info, your brokerage firm's name, your brokerage firm's license number, your name, your license number. And then what I'll typically do is I will also come down here and I will also fill out as much of section 33 as I can when I'm the buyer's broker, right? If I don't acknowledge receipt of the earnest money deposit, I know the listing broker doesn't either. So I can check that box. In IRIS, which is not true for RE Colorado, but in IRIS, it actually tells you what type of contract they have, either exclusive right to buy agency or exclusive right to buy transaction broker. And so you can even fill in this piece, right, based on what they've said in the MLS. And then who's going to pay their compensation or commission? Well, it's not going to be my buyer, right? So I'll just check the seller box, and then I will actually fill in their brokerage firm's license number and their license number if those things don't populate, because it saves them a step. It's less hassle, right? Particularly in a competitive market, I want to do everything I can to get an edge for my buyer. And so if I can make it easy for them by filling in their license number, their brokerage firm's license number, then that's what I'm going to do. Okay. And if you don't know how to do that, give me just a second here. So if you don't know how to do that, just go to Google and type in Colorado real estate licensee lookup. And then you'll see this one that says e-license online. Okay. And it'll pull up this search screen. It looks just like this. And then you could type in Jesse Engel, right? And it's going to have my license number, and then it will have my brokerage firm's name. And you can either search the brokerage firm's name by Larimer County Partners or Keller Williams Realty Partners, and it should pull up. So if I clear out the name, right, and I go to the business name and put Larimer County Partners, it's going to tell you right here, here's the brokerage firm's license number. And you don't need like the EC, ER, EA, you know, any of that type of stuff, just the numbers. Okay. So pretty easy to locate that stuff. That's where you'll find it. Let's see. Andrew chatted in and said, do you need to do a brokerage disclosure if you do the exclusive right to buy? So that's a good question. And the answer is it depends. Okay. If you do an exclusive right to buy right up front at the first reasonable opportunity and prior to soliciting confidential information, motives, that type of stuff, then no, you do not need to do a brokerage disclosure to buyer. However, if you know the reason that a brokerage disclosure to buyer exists is in many cases they're just not ready to get married to you on the first date, right? And so if I'm going on a listing appointment to Brandy, who is my buyer that I'm going to be working with, right? And I say, hey, Brandy, you know, I've got this exclusive right to buy. I'd love to work with you, right? Here you go, sign this. And she's like, whoa, I'm not ready to work exclusively with you. I've never met you before. I don't like, I just want you to show me some properties and let's see if we're a good fit, and then I'll sign it, right? Well, then she's not going to sign that exclusive right to buy. You still have to do then a brokerage disclosure to buyer, because you're disclosing to her, hey, that's fine. I can't be an agent for you. By default, I am a transaction broker for you. And that's all I can be until you sign an exclusive right to buy. Okay. So at your first reasonable opportunity, you should either do an exclusive right to buy or brokerage disclosure to buyer. If you're not going to do an exclusive, then you should absolutely do the brokerage disclosure to buyer. Okay. Does that make sense to everybody? Okay. So that's the end of the contract. We finally made it through. Anybody have any questions about anything in this contract, any other contracts, any situations you guys have come across? Nothing? You guys not drink your coffee this morning, or? Okay, well then that's all I got for you this week. We'll get details out about